God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Well, good morning. Welcome to an oral argument session of the 5th District Court of Appeal. The marshal has introduced me. Along with me today, we've got to my right Judge Meredith Sasso from Orange County. Judge Sasso is also the Chief Judge-elect of the 6th District Court of Appeal, but please don't refer to her as binary. She doesn't like that. And to my left, we've got Judge Orfinger, who is one of the founding members of this court. Oh, wait, that might have been your dad, but I'm not sure. We're up to our 11 o'clock oral argument this morning. I'm probably going to mispronounce this, so please correct me so that we get it right. Thacker? Thacker, okay. Versus Good Gateway LLC et al. Case number 21-848. We are live streaming this, so please be aware of it. We've got a viewership that has reached into the tens, and so just let you know that. If you have any electronic devices, just make sure they're on silent so that they don't interfere with the presentation this morning. We have, as you all know, we've got a 5-minute default for the appellant for rebuttal. That's negotiable, so just let me know what you'd like and I'll be glad to accommodate that. That said, we're ready to proceed.
Good morning. May it please the court. My name is Matt Canigliaro. I am with Carlton Fields, and I am here today on behalf of the appellants in this case, Niloy and Chuck Thacker. I'd like to save about 4 minutes for rebuttal.
Okay.
We have brought multiple arguments to this court in an effort to demonstrate that the summary judgment in this case should be reversed. And I'd like to try to spend a little bit of time on each of them this morning. And I'll start really with an observation, which is that, to my knowledge at least, nowhere in Florida case law, the rules, or our statutes, is there any direction on what is to happen with federal pleadings after a case is remanded from federal court to state court. We've given in the briefing the court some guidance from decisions from other areas, and you see in that there was sort of a majority view at one point that the state courts won't do anything with federal pleadings, we'll just ignore them and go on and litigate. And as that New Hampshire case points out, the more modern view is that we can utilize them, but it's done through some sort of process. In Florida, we have no process. What we do have in this case is a set of filings that were brought to Florida after the federal court remanded back to this state and the Orange County Court. And we have what followed that in the form of a separate cases order. The separate cases order in the state court case looked a lot like the separate cases order that had previously been filed in the federal court case. Both of them said, in essence, that this is a collections proceeding. If there are going to be proceedings supplementary, they need to be brought in a separate case. Florida has a statute that was amended in 2016 in order to reflect these circumstances, and the separate cases order that was entered in this case tracks the statute and basically says if a proceeding supplementary is filed after July 1 of 2016, then it needs to be handled separately. Basically, it can be in the same case, but it needs to be given a separate supplemental case number and needs to be handled separately. That separate cases order was in effect long before the motion for summary judgment was filed in this case, and yet the motion for summary judgment asked the trial court, to enter summary judgment on a complaint that simply came from federal court. So the first argument we've brought to this court today is that it was improper for the trial court here to even address this in this case. It should have been handled separately. And the reason for these separate requirements is to avoid the confusion. And I think it may be understatement for me to say.
What's the effect of that, though? Even if we conclude that this should have been filed under a separate case number and the filing date of September 2015 isn't dispositive, what's the effect? Is your argument that it's jurisdictional, that it's kind of de facto reversible error, and how do we conclude that given the fact that there is no guidance on what trial courts are to do in this situation?
I think the simplest way to look at it is that it is reversible error. It could be characterized as jurisdictional, and I recognize that this court actually has case law that sort of distinguishes between subject matter jurisdiction versus case jurisdiction and other forms of jurisdiction. And I'd be happy to have a discussion about those things, but I think the simplest way to get through it is it's just reversible error to go forward the way it happened here. And to look at the record here, it is manifest that there was tremendous confusion all around. The motion to stay that was filed that then referenced a different summary judgment motion, or that referenced a different proceeding, and then the response to it by the plaintiffs that basically indulged that same misunderstanding of it all is inexplicable. And yet that's what happened here. And so I think the simple answer in the end, Your Honor, is it's just reversible error. I don't think the court has to characterize it as a jurisdictional problem. I think it could, but it is error. And so that's really the first ground for reversing here.
Mr. Coniglio, you think this would have been less confusing if they had simply taken those federal pleadings and put them in a different file with a different number? That would have somehow made this thing less confusing?
The short answer to that, Your Honor, is yes, and here's why. If a separate case number or a supplemental case number is added to a proceeding, it then becomes clear what pleadings, what filings relate to that proceeding. And if a summary judgment motion is going to be filed in that case, we know it's to the pleadings in that case. If the pleadings are in...
What other pleadings were pending in the case? I mean, the judgment had already been filed. I mean, what other... I'm trying to understand why there was so much confusion. What other pleadings were pending?
There were many supplemental complaints and proceedings supplementary that were filed in this case. I don't remember the number. It's 5, 6, or 7 or thereabouts. And I may have lost track of how many it ended up being. But there were many. And because of that, you had... And some of them overlap with different defendants that were maybe in 1 or 2 here and not over there. It is very easy to get confused. And when you combine that with the remand situation where I think it's 20,000 pages or more, 30,000 pages of documents were brought from federal court and just filed here. And they came from 4 different cases in the federal system. They had 4 different case numbers in the federal system. And when you look at the hearing and how all this came to pass, it is, I'll suggest, very clear there was tremendous confusion, and it would not have happened. The confusion, I mean, would not have happened had there been a separate case and it been clear the motion for summary judgment was filed in that case on the complaint in that case.
So why, applying this rule, would we not relate back the supplementary proceeding to the date that it was filed in federal court?
Well, when Your Honor says relate back, the phrase catches my ear because that can mean different things in different contexts. Here, it would mean what it should mean is when was the document filed. Mm-hmm. And relating back really shouldn't apply as a concept. There might be limitations purposes or other purposes that you might say for those purposes it relates back. But if we're talking about when the document was filed, then it was filed in August of 2016. And so the statute should apply to it, the separate cases order should apply to it. But even if this court disagrees regarding that set of circumstances, when we get to the merits, this is still reversible error. Res judicata was the basis for this judgment. The defendants on this supplemental proceeding are Niloy and Chuck Thacker. The defendant in the New York case that was the basis for the res judicata arguments was Rohan Thacker, Chuck Thacker's son, Niloy Thacker's brother. He was the only defendant in that case. The summary judgment order in this case says that the parties were the same, the issues were the same, the lawyers were the same. And as I think we point out with some emphasis in the briefing, none of that was true. The parties weren't the same. The issues weren't the same. They were similar. They involved loan forgiveness that was alleged to have been fraudulent under the circumstances. But the parties were not the same. The issues were not the same. I'm not sure it matters, but the lawyers weren't the same either.
Can we talk for a minute about preservation? How was this specific issue, which is the issue that interests me the most, how was it argued below? How was it teed up to the judge that, hey, we're not privies, we're not parties to the New York action, and we shouldn't be bound by it?
The briefing, I don't have the specific pages here. I can get them for when I come back up. But it was part of what was essentially a lengthy argument that was made in the trial court. And the argument was made, albeit briefly, that we don't, res judicata can't work here. We don't have the same parties. The answer brief in this case acknowledges that point. In the answer brief's account of what happened below, it says accurately that we argued below that res judicata couldn't apply. So it was teed up. I will agree that the focus of the arguments that were made below concerned the federal court jurisdiction points, but it was said as well that res judicata would not apply here. They weren't the same parties. It was Rohan up there, and it was Chuck and Niloy here. And on the merits of that, it is, I'll suggest, extremely clear that res judicata can't work here. And it is a distortion of the case law to try to find anything that would support the notion that it could work here. The trial court said these were the same parties. They weren't the same parties. The trial court also had a language in the order that said, well, or they're privies. But there was no effort to even show someone was a privy here, let alone a successful effort to show that. Nothing in this record supports that they're privies. They're family, but they're not privies as a legal matter. And so res judicata is a difficult burden, and it should be, because it's preclusion, it's claim preclusion. And so you have to line up with identity of parties, identity of claims, or identity of causes of action, et cetera. And here that cannot be done. The claim that was litigated in New York was a different claim against a different person, similar circumstances, but not in the league or the realm of res judicata. The third sort of set of arguments that we have for the court sort of moves from there into what I'll suggest are the additional just sort of indicia of how unjust this judgment was. The complaint in this case alleged a fraudulent transfer claim. The motion for summary judgment didn't spend one moment attempting to prove that claim, other than to say, this is res judicata. Res judicata was never pled in this case. It was never pled because it couldn't have been pled as a practical matter. When the supplemental proceeding was initiated in this case, and I think it was 2015, the New York suit hadn't been brought yet. So all of the events that are essentially at issue here in terms of res judicata were unpled. And it is a matter of sort of basic due process, and as case law holds, that a judgment is void if it enters judgment based on issues and claims that were never pled. That's what we have here, and this is a direct appeal, so we can raise those things.
I mean, is that not complaining a bit like what was pled as the basis for entering the judgment? And the motion for summary judgment lays out each of the issues that the final judgment was based on.
That's true, and Your Honor, we're not suggesting there wasn't notice on the summary judgment, but there was not a pleading that set out those claims. And so
Res judicata can be used offensively, though.
it can. We agree with that.
And
But it would need to be pled. It would need to be raised.
Do you have a case for that proposition that res judicata would need to be pled in a complaint if it was to be used offensively?
I don't, but I'll suggest it fits within the usual framework of the issues must be pled. If you're going to have a claim, if you want to bring a claim based on res judicata, that claim should be pled. We should really never have a situation where we show up at a summary judgment hearing or a trial and litigate things that are just nowhere found in the pleadings. Of course, the case law allows for amendments by implication and that sort of thing. That's not what we have here.
And I think you argue this is fundamental error, correct?
We do, Your Honor.
So in recognition that that was not the argument raised below, how could there be fundamental error here when there is an opportunity to raise that in response to the motion for summary judgment, and then again in response for rehearing? How do we get to a fundamental error analysis?
Well, first of all, on the second part, I am unaware that a motion for rehearing is necessary in order for something that's fundamentally erroneous to be recognized by the appellate court as fundamentally erroneous.
I think more when we're viewing it through the due process lens, if that's what it is here. When there was, as you said, notice through the summary judgment, and then another opportunity to correct any error in a motion for rehearing, why do we reach a conclusion that there was a due process violation, a fundamental error due process violation?
I'll suggest this. The focus of the opposition to this motion was that the whole summary judgment motion should not have been before the court for multiple reasons, jurisdictional and related. And at no point was there any kind of waiver or concession that we should be litigating these issues. And I mentioned to the court that there was brief argument regarding the point that these parties are different, so on the merits, res judicata should not apply. But this is not a situation where there was any sort of waiver or concession that we should be here. The claims that were put forth were based on res judicata, which is entirely unpled. The relief that was sought was also unpled. And so it's a similar set of problems regarding relief. As to Neloy Thacker, it's perhaps the most obvious, but it sort of leaps out. He was given the judgment that was entered against his brother. The amount of the judgment against Neloy Thacker is the judgment against his brother in New York. It's not what was brought to this court, what was brought to the trial court as a pleading in this case. And nothing about the way this was defended was any kind of concession or waiver of the ability to say, wait a minute, this was just completely out of bounds. And at a minimum, we would ask this court to consider the circumstances of all that in order to decide about really the first two issues in this case.
Sorry.
You're into your rebuttal.
I'll just really quickly say, and with regard to Chuck Thacker, there's a similar line of argument that he was the judgment debtor. This judgment ends by doing something that I'm not even sure the motion for summary judgment requested this, but even if we indulge it and say that it did, that the pleadings had never requested it anywhere, which is enter a judgment against the judgment debtor based on an alleged fraudulent transfer. And we've done an analysis in the briefing of why Judge Wetherill is correct, that under Florida law today, as it stands, including a governing Florida Supreme Court case, that is completely improper, because the statutes do not allow for relief like that against the judgment debtor. It doesn't even make sense as a practical matter. If the judgment debtor transfers money away, you give the judgment creditor an additional judgment in that amount. So if you owe somebody $1 million, but you give that $1 million to somebody else, you now owe the judgment creditor $2 million. Judge Wetherill is correct. So for all these reasons, both with regard to how this case got from federal court into the system here, how it should have been based on an order entered, not just in the federal court case, but in this case, the separate cases order, that this was not properly before the court. And of course, res judicata on its merits does not work here under these circumstances. And then the additional issues that we've raised really as fundamental error. This was unjust. This should not have happened. And we ask this court to reverse. And I'll reserve the balance for rebuttal.
Mr. Baganoff?
May it please the court, John Bogdanoff for the appellees. Just 2 quick points before we get into the more substantive ones. The argument about the judgment being entered against Chuck Thacker, if the court looks at the summary judgment, it'll note that the court granted the motion for summary judgment against Chuck Thacker and Neloy Thacker. However, in paragraph 2, the order states this court enters final summary judgment against the defendant, Neloy Thacker. In other words, summary final judgment was not entered against C. Thacker. So the argument that somehow this judgment is a judgment for money damages against C. Thacker is not correct. The judgment does not award final summary judgment in favor of Mr. C. Thacker. So that issue I think we can dispose of. The other issue is, yes, the amount is incorrect in the summary final judgment. The debt forgiveness, there were 2 different amounts. They varied by about $200,000. One was 2.6 and one was 2.7. One was about 2.5 million for each son. And in entering the summary final judgment, the judge did erroneously enter the amount that was involved in the R. Thacker, the previous case. So we would suggest that when we get to the end of the line on this, that the final summary judgment should be affirmed. However, the court should be directed to correct the amount to reflect the amount of the debt forgiveness plus prejudgment interest that's involved with N. Thacker. So I think that issue also can be disposed of fairly straightforwardly. The other issues that are raised, and this is unfortunately, and when I speak about opposing counsel, I'm not referring to Mr. Conigliaro because he's only been involved in this since on the appellate level. But going through this case, I think it becomes very evident that many of these, in fact, just about all the pleading issues, even the collateral estoppel issues, were never raised below by the Thackers. When we have the pleading situation, the Thackers were primarily concerned with the fact that when this case was remanded from the bankruptcy court by Judge Jenneman in 2016 back to the circuit court, her work was done, remanded back to the circuit court, Orange County Circuit Court, they were concerned ultimately, not initially, but as this case progressed, they realized that a certified letter had not been sent from the clerk of the bankruptcy court to the Orange County Circuit Court. There's a federal statute that suggests that that is something that needs to be done. However, it wasn't done in this case. Nevertheless, the 11th Circuit, in a recent opinion which we provided to this court, rejected their claim that that rendered the transfer of jurisdiction from the bankruptcy court to the circuit court somehow invalid. The 11th Circuit rejected that argument. That was the thrust of their argument below, that somehow this thing never should have even been in the circuit court because the remand from the bankruptcy court was improper. Having that issue kind of off the table now, as the Thackers have withdrawn that issue on appeal, as they should, since the 11th Circuit has rejected that, we're now relegated to talking about some pleading issues that they feel at this point they should be allowed to raise. None of these matters were fully raised in the trial court. No written response to the motion for summary judgment was ever filed.
Do you concede that none was required?
No, I don't. And the reason I will not concede that is because the motion for summary judgment did allege grounds for use of collateral estoppel in this case. It included attachments. It included the complaint that had been filed, the supplemental third-party complaint that had been filed in the bankruptcy court. It included the answer that the R. Thacker and N. Thacker, a joint answer that they filed to that supplemental third-party complaint which alleged fraudulent debt forgiveness. They filed a joint answer raising the same 2 defenses. Also attached to the motion for summary judgment were the 2 letters that Chuck Thacker had written to his sons in 2012 granting them the debt forgiveness.
So they would have had to file if they wanted to controvert those facts. But if they didn't want to controvert those facts, what sort of response was necessary other than whatever they chose to argue at the hearing?
Well, if they wished to controvert the facts that were asserted in the motion, then yes, they would have. If they
Well, but
if they
the
decided
collateral
to,
estoppel isn't a fact. That's a legal argument. The facts are things like, this is the answer that you filed, this is our judgment, that sort of thing. Those are the facts. Collateral estoppel isn't a fact, is it? Isn't that a legal argument?
but the facts supporting collateral estoppel were set forth in the motion for summary judgment. They were provided by way of attachments and exhibits to the motion for summary judgment.
So my question, though, is what were they required to file that they didn't file?
If they wanted to contest any of those facts, they were required to file a written response under Rule 1510. If they did not wish to contest any of the facts as alleged, they didn't have to file anything.
So you would agree then that they could dispute whether or not this motion for summary judgment was sufficiently supported through argument without filing?
No. If they wanted to contest whether or not the motion was, which alleged, among other things, collateral estoppel in this case, the 4 elements of collateral estoppel, the facts supporting that, they would have had to file a written response, and they didn't. So all of
And the legal argument as to whether those facts constitute collateral estoppel, satisfy the elements of collateral estoppel, legal argument, they could present that in hearing.
yeah, I mean, they could, make a
Do you
legal
agree that, albeit briefly, was raised in the hearing on the motion for summary judgment? At the motion for summary judgment?
whether or not the facts as established,
Whether or not res judicata or collateral estoppel, from a legal standpoint, applied in these circumstances, was briefly raised at the argument.
if it was not clearly raised in my reading of the transcript, I cannot say that, no. Their focus at the hearing was primarily on the jurisdictional issue about the remand from the bankruptcy court. In fact, towards the very end of the hearing, counsel for the Thackers even says this to the court. He says, this court needs to figure out how a case that comes to the court that has no case number becomes a case before the court. But that's not part of our argument today either, Judge. In other words, they're not focused on, well, it doesn't have a separate case number, there wasn't an adequate pleading file. Their focus at the hearing below was on this jurisdiction, this remand jurisdiction from the bankruptcy court. And they, even towards the end of the hearing, they tell the judge, we're not here to, argue about the absence of a separate case number. Their focus was not on that. They never raised those specifically raised issues about the status of the pleadings to the court. They never objected when the pleadings from the bankruptcy court were filed with the clerk of the Orange County Circuit Court. In fact, they acknowledged they may have even filed the supplemental third party with the clerk. The case proceeded for several years without any objection. The motion for summary judgment is filed in January of 2020. It's not even ruled upon for over a year. Never raised any issues about the status of the pleadings. It's only when we get to that short hearing on the summary judgment that they start talking about the jurisdiction, and it's primarily related to the jurisdiction on remand from the bankruptcy court. The trial judge was never given the opportunity to consider the issues that are being raised on appeal. He had no opportunity to consider all of the things that have been raised in connection with this appeal, insofar as the status of the pleadings is concerned. So it's our position that the judge heard the argument, considered their claims, and concluded that this case was ripe for summary judgment. Have no real doubt as to the fact that this was a case where collateral estoppel applied. We have the same issues, the debt forgiveness. The only difference is in the amount. The letters are identical, save for the amount.
How is it the same issue? It's a loan made in a father and son relationship, correct? 2 different sons.
Yeah, father and his 2 sons.
So how do we presume, from a collateral estoppel standpoint, that it's the same legal issue when there are conceivably or could be 2 different circumstances?
They filed a joint answer. They raised the same 2 defenses. Those same 2 defenses were litigated in New York, and were rejected by the court in New York. The two defenses were Mr. Thacker was solvent. New York court said, nope, didn't prove that. The other defense was reasonably equivalent value. New York court said, nope, you didn't prove that. New York court said this is a fraudulent transfer when it came to R. Thacker.
And who are the parties in the New York case?
R. Thacker and my clients.
Right.
Mr. Thacker testified and provided an affidavit in the New York case in support of his contention that, this was not a fraudulent transfer, fraudulent debt forgiveness. The New York court rejected that.
So how do we get then, even if we agreed on that, how do we get to same parties or privities?
Privies, I think under the case law that the court cited, as well as we cited, the Aerojet case, as well as the McQueen case, the court says that even though a party is not a party to the previous litigation, if the parties to the earlier suit are so closely aligned with their interests as to be his virtual representative.
And Aerojet was clarified in Pollard to require the existence of an express or implied legal relationship? Or is it your argument that there's any legal relationship when we think of a brother-to-brother?
Well, and also McQueen also cites the same principle of Florida Supreme Court case. But in this case, there's simply no basis, and that's why there was no contest, no written contest of the facts supporting collateral estoppel, because we have not only the relationship, we have a single answer, a joint answer that was filed raising the same exact defenses. Those same defenses were fully litigated in the New York action. Mr. C. Thacker participated as a witness in that. The defenses were rejected in the New York action. That judgment has been domesticated in Florida, so it's in effect given the same.
I'm still having a hard time seeing how we make the jump to application of collateral estoppel without that legal relationship. That's necessary. Go ahead.
I think you do it based on the facts that were alleged and the absence of any facts contesting that.
Was privity raised as an issue at the summary judgment hearing? Was privity raised as an issue at the summary judgment?
No, I don't believe it was. The focus there was this jurisdiction, situation. Certainly, there was no contest as to the facts as alleged in the summary judgment motion and supported by the exhibits. And I think in this case, all of the evidence that was before the court indicated a relationship that satisfied the Aerojet as well as the McQueen case, that these parties were essentially virtually representatives of each other. The causes of action were the same. The defenses were identical.
Mr. Bogdanoff, just help me with the facts of the case a little bit. When you say that they filed a joint answer and raised the same two defenses, you're not talking about the New York case. You're talking about in Florida. Is that correct?
In the case, the answer was filed in the bankruptcy court. The supplemental third-party complaint was filed in 2015 while the case had been removed to bankruptcy court. The answers were filed in that action. Then, subsequently, the case is remanded back to the Orange County Circuit Court. The pleadings at that point were then filed with the Orange County Circuit Court.
In New York, the only answer was filed by R. Thacker. Is that correct?
Yeah. The jurisdiction couldn't be obtained over R. Thacker in Florida, so jurisdiction was obtained over R. Thacker in New York, which is why the case was litigated in New York. Same complaint, same answer. It was all the same. The debt forgiveness letters are identical. The same date, except for the amount, which was because they each owed a little bit less one owed a little less than the other one. But everything was identical. The same causes of action. So we believe that the court was correct based on the record before it in entering the summary judgment. These are judgments that go back. This court affirmed these substance of these judgments back in 2017 by way of a PCAs. This case has been continuing on for 5+ years in an effort to satisfy the judgments. And we think the trial court was correct in entering the summary final judgment. with the caveat that the amount is incorrect and should be, remand should be ordered for the judge to correct the amount to reflect the amount that N. Thacker owes, which is about $200,000 less than the R. Thacker, plus prejudgment interest.
All right,
Thank you.
thank you. All right. Mr. Conigliaro, you have just over 2 minutes.
I will try to be very quick, Your Honor. First, to return to the preservation questions, I have in my notes, but not the pages with me, pages 8418 and 8425 of the record. We argued that that was Rohan and his claims. This is Chuck and Neloy. And that is enough to preserve this for review, that we were disagreeing on the merits of res judicata. The answer brief at pages 13 to 14 says, a telephone hearing was held on the motion during which appellants, despite having failed to respond to the motion, claimed for the first time that there was not a proper remand, that Appellee's supplemental third-party complaint had not been properly filed, and that res judicata and collateral estoppel did not apply. So until right now, there's not been disagreement over that portion at all. With respect to the case being litigated for 3 years or 3.5 years, let's focus for just a moment on what the case is. This supplemental complaint wasn't litigated at all. We went back and checked, and not one thing that we could find was done in Orange County related to this supplemental complaint in that 3.5 years. 30,000 pages of documents came from federal court, or whatever that number was, and 3.5 years later, a summary judgment motion gets filed on a document that our trial counsel was very confused about what was at issue here, as the motion to stay sort of shows. With regard to the joint answer being privity, there's nothing in the law that supports that. That would be a radical departure from precedent to say that because people are represented by the same counsel filing a joint answer that they're now bound by other litigation.
Is that raised below?
I'm sorry?
How was that raised below?
By the argument that it wasn't us, that these weren't, that this is Chuck and Neloy, that was Rohan. And that was what we argued below. That's what we're arguing here. We're certainly expanding on the
I understand
argument.
that's a little different than the privity argument.
Well, no, I'm going to disagree, because the privity argument is a way to get around, it's their effort to get around that they're different people. On the face of the summary judgment motion, these are not the same people.
Right. Or your time has expired.
I thank you.
Thank you both for your argument. Thank you. And we'll be in recess.